Now, as I mentioned in the previous module, you're going to respond to each individual numbered paragraph contained within the complaint. They're generally set up the same way. They vary according to the attorney who produces the complaint, but in general, there'll usually be some kind of jurisdictional statement saying, hey, this is the proper place for this to be. This county that it's in is the proper place. Usually one or two paragraphs, and you'll see that in the sample answer and sample complaint, that is a jurisdictional thing. Now, sometimes it's just there. Sometimes they'll have a heading that says jurisdiction, and then there'll be another heading that says parties, and another heading that says facts, and another heading that says count one. And if they have those different headings, then you can go ahead and probably should put those headings in your answer and then respond. It just helps everybody to kind of follow along where you're at in responding to the complaint. All right. So if you look at the very first thing that there, it says, hey, this is jurisdictionally correct. And usually our response to that is admitted for jurisdictional purposes only, which means, yes, you know what, we agree with you that this is the proper place to be, but I'm not necessarily agreeing that this is a proper complaint, just that we're saying it for just for this purpose, for jurisdictional purposes, we agree with you. Okay. Now, you're either going to say in general, either admit, so you're admitting the allegations contained within the paragraph. You're going to say deny, which means you completely deny it, know what, period. Or you're going to say without knowledge, and therefore deny, which means, you know, you're not really sure if the answer is correct, but just because you're not sure, you're going to say you deny it. And that way you're going to play it safe. And in addition, sometimes you do a hybrid of that where you say, you know, I admit to this part of it, but I don't admit to that part of it, so I'm denying that. So that's the kind of stuff that we're going to show you as we go. All right. So, you know, don't just deny everything just to deny it. The judges get irritated with that when people do that. So, you know, if they say that you're the owner of the property, don't deny it. If you really are the owner of the property, just admit it. I mean, there's going to be a lot of things that you have to admit. You know, you could admit that you actually entered into a promissory agreement. Now, things that I typically don't admit to, though, is that they've attached a true and correct copy of the promissory note and the mortgage. Well, how do I know that it's a true and correct copy? Well, a lot of times what they have is copied things that were from the closing, but they have subsequently done things to the promissory note where they have additional endorsements and things like that. So I don't know that they've got attached a true and correct copy. So as you can see from the example, that's not something that we're typically going to admit to. So what I want you to do is look through each and every one of the allegations, look at the sample answer, and I want you to respond appropriately. Go through and do you admit this or you deny it? Be careful about what you're admitting to, because I don't want you to make the case for them. So if they say that they've attached true and correct copies, you've kind of basically admitted their case for them if they've got all the other documents there. So again, be careful about how you do that. All right, and just look at the sample on doing it. Now, again, go back to the pleading section if you want to see how this is all put together. But in general, you have that first part where you say answer. You have, hey, I'm answering. Here's my specific answers to the specific paragraphs in the complaint. You have your signature block where you sign it saying, hey, I'm signing this. And at the end, you have your certificate of service. In addition, in the answer, I'm going to want you to put what are called affirmative defenses. And these are defenses that you can raise specifically to the complaint. And what's an affirmative defense? Well, it means, you know, yeah, some of the allegations may be right, but besides that, I've got some defenses to it. And there are all kind of affirmative defenses you can potentially raise. There are several that we typically will raise in a foreclosure case. And for instance, let's start with the first one, lack of standing. So let's say, you know, in your motion to dismiss, you said, this guy is not the right person to bring this lawsuit against me because the promissory note isn't right, the assignment isn't right. And let's say the judge said, nah, you know what, I don't care about that. And it was just, your motion to dismiss was denied. Well, you still have that defense just because the judge wouldn't let the motion to dismiss go through, so you still want to raise it. Lack of standing, same thing. You raise it. Now, if you look at the sample answer, you're going to see in the affirmative defenses, that's one of the very first things we put is lack of standing. You're still objecting to that. Okay? Next one. This one, I just throw it in just because it irritates them. Unclean hands. This is, they did something bad. They don't have a right to foreclose on you because they didn't do something right. Well, typically, it's because they didn't do modification programs like they should have. There are any number of reasons. But if you just look at the unclean hands affirmative defense, I would just stick it in there. Again, it usually doesn't go anywhere, but it's kind of fun to stick in there. TILA violations. Now, this is Truth in Lending Act violations, what we call TILA. Let's just say that this is an affirmative defense you can raise. We have an example of that in the materials, and then we're going to talk about that in more detail down the road. This TILA is kind of a very, very technical subject having to do with the Truth in Lending Act and whether they complied appropriately to that, and right now I'm just not ready to go into it. All right. RESPA violations. This is the Real Estate Settlement Procedures Act. This is if there's all kind of, again, this is probably more technical than I want to talk about in this case at this point in this module. But just I want you to be aware that there are things that we can talk about, and we're going to have other modules where we discuss this in particular, the RESPA violations.